religion is part of law, then it is just not possible to have a uniform civil code. Always, when we have a uniform civil code, remember, we have to think of other factors as well. And you have to prime consideration for national interest. Now, jus gentium simply means it is a law that was enacted only to the foreigners. In the event of a foreigner visiting the territory of Rome, in the event he was finding in the jurisdiction of the state of the Roman Empire, a separate law was made applicable. And this jus gentium at a later stage was called as international law. Law of nations. Uniform civil code is gaining momentum today. It is gaining momentum at the offices of the political parties as well as even in the minds of citizens of this country. I just intend to speak to you something known as codes, C-O-D-E-S. What is this code? Are there any instances or illustrations when a state has adopted a code? Did it include like the law of marriage, the law of succession, the law of transfer of property, or the law of wills, or the law of gifts? This is the fundamental question which we should know. Otherwise, it is very difficult for anybody to speak on uniform civil code. Now, the Roman Empire came to be established in 529 BC, before Christ. And Justinian happened to be a famous emperor whose, remember, life and style and imagination is being studied by students of history as well as students of law. Justinian, during the course of his administration, thought of establishing a Roman code, which later was called as the civil law of Rome. So the civil law of Rome, which is called as jus civili, how it came to be established? In order to bring in jus civili, the civil law of Rome, Justinian had appointed several law commissioners, and these law commissioners were requested to draft and to put in the existing law by way of codes. So when they were requested to put in the law by way of codes, the task was not that easy because he wanted it to be a permanent code, regularly to be applied, regularly to be practiced. So when I speak of the code, remember it had not only the substantive law but included the procedural law as well. For purpose of including this, the commissioners, the law commissioners, remember, had to put hard work. Having put hard work, they were able to establish the Roman codes. And these Roman codes which were established comprised of what? It comprised of what we call as the law of property. It comprised of the law of succession. It comprised the law of endowments. It comprised other branches of law relating to individual liberty, marriage and succession as well. That is why the Roman society was able to function very effectively. And the state of Rome had conquered several cities. And when they conquered several cities, it became part and parcel of the state of Rome. And the law that was enacted by them was made applicable in these territories as well. Now, when we come to what we call the 3rd century BC, they made another code as well, along with the jus civili, that is the civil law of Rome, they made another code. And this is what we call as jus gentium. Now, jus gentium simply means it is a law that was enacted only to the foreigners. In the event of a foreigner visiting the territory of Rome, in the event he was finding in the jurisdiction of the state of the Roman Empire, a separate law was made applicable. And this jus gentium at a later stage was called as international law, law of nations. Now, this is how it is being done and followed and accepted. And the Roman Empire, from as I just pointed out, this from 573, Justinian's period came in 529. From 573 to 31 BC, they ruled the empire. And remember, they ruled the empire very effectively because of jus civili. This is a fact of life, which everyone points out if you read the history of the Roman Empire. Now, what has happened was the glory of the Roman code spread far and wide. And it entered the portals of the state of Germany. And the state of Germany wanted to practice this, and a few of the codes were applied by the state of the Roman Empire. Now, thereafter, what has happened was the state of Austria, when we come to the modern times, adopted the Roman codes. See, the very purpose of telling this is the impact of jus civili, or the civil law of Rome, brought in by Emperor Justinian, ably assisted by the commentators on law like Appian, Pelpian, Gaius, and a host of others were responsible in keeping its durability. Now, it spread to the state of Austria, then it went to the state of Prussia. Thereafterwards, it was accepted and practiced even in the Bavarian Republic. That is the greatness of the Roman codes, because it contained all laws including marriage, succession, and transfer of property, etc., etc. Then we come to the history of the state of France. When we come to the history of the state of France, there was a great emperor. And this emperor has fought more than 40 wars, and he was a great success as well. And he is none but Napoleon. Napoleon, the moment he came to power, he became the general as early as 1893 and became the emperor in 1804. 1793, he is the general, and 1804, he became the general of the state of France. So immediately he asked the advisors, especially the legal officers who are eminent men, to draft a code for the state of France. It is popularly known later stage as Napoleonic Code or Code Napoleon. Now when we speak about Code Napoleon, remember, the first part is there were as many as 300 laws which were prevalent in the state of France when he became the emperor. And all these 300 laws were to be converted into codes. Now when I speak about converted into codes, it should have substantial law as well as procedural law. How it should be applied and in what manner it should be applied, to which court it should go. That also was pointed out. And Code Napoleon, remember, became. A great historian by name Granton Temperley, while speaking about Code Napoleon, he just pointed out, if the wars of Napoleon were ephemeral in nature, it lasted only for a few years. His civilian administration, because of Napoleon Code, was built on granite. It was so perfect, so sound. And when Napoleon, remember, was taken to St. Helena after the Battle of Waterloo, he survived up to 1821. Although he was defeated in 1815. Many states wanted to accept it, remember, it ditto, just like copycats. Now there were states which were under the occupation of Napoleon, and most of them happened to be European states. One such state happened to be the state of Holland. The second state happened to be the state of Luxembourg. And these states, remember, accepted Napoleonic Code for several years, almost 80 years it went on practicing. Later it spread to the other part of the state of Europe, and many of the European countries had accepted the Napoleonic codes. The impact of Napoleonic Code was such, it even went to Latin America. Both the state of Haiti and the Dominican Republic adopted Napoleonic Code even without a single change. Now this code, remember, naturally contained everything. It is not only law of marriage, it contained spoke about the law of divorce, the law of property, the law of succession, all of them. They were part of the code. And that is where it was able to influence even Latin American countries. And at a later stage, even Chile, the state of Chile, and Laos followed the Napoleonic Code. This, in brief, remember, is something relating to the Napoleonic codes and their influence, and prior to that, the Roman codes. Now, what about the prevalence of what we call as the directive principle of state policy, as well as Article 44 of the Constitution of India? Now, when I speak about Article 44 of the Constitution of India, it simply says, the state shall endeavor to provide what we call as uniform civil code to its citizens throughout the territory of India. So it is in Part 4 of the Constitution. Since it is Part 4 of the Constitution, the courts cannot give a directive to enforce it. But most importantly, Part 4, remember, is the actual guide for the governance of this country. The governance of this country has to take place through this code only. Now, when thereafter, we'll just go to the Constituent Assembly itself and the debates. Now, if you just go through the Constituent Assembly debates, which are available from 1948, December 23rd onwards. In volume 7 and page number 23, there is a statement which is being made by Dr. Ambedkar. Dr. Ambedkar simply says, come what may, we will not thrust and force the uniform civil code on the minorities. This is what he said, because what was the reason for this? But before giving the reason of that, what exactly was the comments of the Constituent Assembly members? Now, I just intend to speak about 3 or 4 members only. They are the ones who are vociferous and strongly argued for the Uniform Civil Code. Now, we start with the K.M. Munshi. K.M. Munshi, when he spoke about the Uniform Civil Code, if the minority communities, general, no reference to anybody, if they say that religion is part of law, then it is just not possible to have a uniform civil code. Always, when we have a uniform civil code, remember, we have to think of other factors as well. And you have to prime consideration for national interest. Then what did Ambedkar point out? Ambedkar is the man who, when there was argument from both sides when it was going on, he just pointed out uniform civil code is just possible. Why it is not possible in this country? Although he gave an assurance that it will not be thrust on them. He was just concentrating on the criminal administration of justice. Now when we speak about the criminal administration of justice, he was speaking about the Indian Penal Code. He was speaking about the Criminal Procedure Code. He was speaking about the Civil Procedure Code. The entire Criminal Procedure Code is made applicable to all the citizens of this country. There is no difference between caste, creed, and minority or majority. Everyone has to accept this. Then you think of the law of contract. The law of contract is being applied to everyone, whether you are a Shia or a Sunni or a Brahmin or anybody. When you go to the court of law, it has to be applied, and there is no distinction as far as this law is concerned. And then he went to the extent of pointing out a few other laws as well. And I speak about the few other laws. These are instances which he gave in the Constituent Assembly. The first instance happened to be the instance of the state of Kerala. In the state of Kerala, in the Malabar region, in the North Malabar region, when we speak about the feminist law, you have Marumakkatayam cult. So it is called as Aliya Santana in Kannada. If you go to the Kasaragod region, they speak about Aliya Santana. So the Aliya Santana law, Marumakkatayam cult, is applicable, was made applicable both to Hindus as well as Muslims. And it was done without any trouble, without any problem. And it was observed, adhered, respected peacefully by all the communities with it. Although it was meant only for a segment of the people, it was applied even to Muslims. Then he was giving the illustration of the law that was prevalent in the northwestern frontier. In the northwestern frontier, remember, there was no Sharia until 1937. Sharia, and it was implemented only after 1935. It was implemented after 1935 because until that date, all the Muslims were following, as in regard to succession, the Hindu law. So the Hindu law of succession prevailed in the northwestern frontier. The northwestern frontier at that time, remember, it goes to beyond the present Afghanistan. If at all, it was part of the state of India. Think of it. Now then, he gave the illustration of the Bombay province. In the Bombay province as well, that is the Maharashtra province, up to 1937, there was no implementation of the Sharia for Muslims. Only Hindu law was applied. Now, in addition to this, even in the central provinces as well, up to 1937, the Hindu law actually prevailed, and there was no what we call as Mohammedan law or the Sharia, which was made applicable to the Muslims. So when that was done, when that was actually peacefully applied and peacefully received, and cases are being resolved, what is the hitch and hiccup? This is the fundamental question which everyone should ask. Now, if these are the things which he said, I just told you about Ambedkar, then what did Alladi Krishnaswamy Iyer point out? Alladi Krishnaswamy Iyer simply said, now you have laws which are enacted by the British government, and these laws which are enacted by the British government are actually influenced by the Anglo-Indian jurisprudence. And this law which is being enacted by the government of India through the British were influenced by the Anglo-Indian jurisprudence. Naturally, it was made applicable to Mohammedans. Then he was just saying, if you take into consideration the application of contract law prior to 1948, 1950, remember, it was applied between Muslims and Hindus and Muslims. I am quoting the statement of the great Alladi Krishnaswamy Iyer. Oh, when it was applied like that, where is the hiccup? And this should not be allowed to be done. K.M. Munshi always wanted to say, if religious considerations are taken into consideration, I don't think we will have a uniform civil code in India. And it is just not possible. Now, having said this much, I just intend to speak to you a few of the cases which were decided by the courts and what exactly the issues that are involved and what was the law and how the judgments were delivered. Now, one such case happened to be, which most of you know, Shahbanu's case. It was 1985. In 1985, the famous Shahbanu case came up. And Shahbanu happened to be a woman who was 62. And at the age of 62, she was divorced by pronouncing talaq. And remember, she was ousted from the house. And the lady goes to the court of law and asks for maintenance. When she was asking for maintenance, the court granted alimony and maintenance, whatever it is, under section 125 of the CRPC. Now, when this was done, remember the Muslim communities just did not like this. And when they did not like this, the maintenance for a divorced woman under Islamic law can be given only for 100 days. That is to the period of iddat. When once the period of iddat gets over, she is not entitled to any kind of compensation, whatever, from any source. Now, Muslims said, why the courts are interfering in the administration of justice? Now, this is Islamic law, and this is fundamental to us. And the administrators, the ruling people, wanted to influence the voters and to get their support. And then came a law that was passed by the then government. And they said, Muslim women's protection in the event of divorce. And the law simply stated under 3.1, she is entitled to claim compensation only during the period of iddat. At a later stage, this was challenged in 2 cases. I don't wish to make a mention of those cases. And in those 2 cases, when it was challenged, the court pointed out that any law which is being enacted by the parliament, if it contravenes section 125, it is unconstitutional. Very simple. So, with the result, the law which was enacted, remember, for providing iddat only for 100 days was considered unconstitutional, and there was a deep burial. See, this is the first day wherein in 1985 the issue started surfacing. Now, there are instances wherein they went to the extent of pointing out what we call as uniform civil code is very much essential. And that will solve the problems. And in order to solve the problems, it has to be done come what may. And when this was done, there were cases, a beautiful case came up, Sarala Mudugal versus Union of India. And in Sarala Mudugal versus Union of India, the question is very simple. Now, what has happened is, here is a person, Mr. X, he gets married to a lady under Hindu law. The marriage has taken place under the provisions of the Hindu Marriage Act, 1955. And thereafterwards, remember, he intends to take another wife after converting himself to the Islamic faith. His marriage has taken place under Hindu Marriage Act, and he converts himself to Islam. Then he takes the second wife. Now, when it was challenged before the court of law by an NGO known as Kalyani, which was led by Sarala Mudugal, the first issue is does this relate to bigamy? Section 493 of the Indian Penal Code. It hits the Indian Penal Code or not was the question that came in. See, during the subsistence of the first marriage, when the first marriage itself is in force, a Hindu who has married and taken a wife in accordance with the Hindu law, how can he take the second wife? And if he takes the second wife, remember, the law of bigamy will come into and it will hit and the marriage is void. So it is at this juncture, during the course of judgment, they said, now what we call as uniform civil code is very much essential. Now this is only to unite and to keep the integrity of the nation. And naturally, to keep the integrity of the nation, a uniform one law for one nation is a must. This was another. There was another case which came before the court of law, and in this case, that happened to be the third case, remember, a Muslim woman wanted to adopt a child. And in the Islamic law, it was not allowed, because in the event of adoption, she is not equally treated. But then there was a legislation which was passed by the Indian government, and which is popularly known as the Juvenile Justice Act. Under the Juvenile Justice Act of 2000, Muslim woman is entitled to adopt a child. And she adopts a child. And when the matter goes to the court of law, the court pointed out, no, there is nothing wrong in it. And naturally, everyone should come to the mainstream. The law should be uniform, and it should be made applicable throughout the territory of India. Now, these are a few cases that came for purpose of discussion. Now, the other part of the story is 2-3 issues came up. One is whether the rituals or whether the practices and the precepts of a particular religion come in the way of the adoption of the Uniform Civil Code. Your practices and beliefs and the precepts, you are entitled to firm up. Nobody will interfere. Nobody will interfere with that. Only thing is, everyone has to be treated equally. In Sarala Mudugal case, and subsequent to that, there was another case which came up, wherein the judges of the Supreme Court, especially Kuldeep Singh and another, they harped upon in saying, all laws, whether it is based on religion or whether it is based on morality, must undergo the test of human rights. And if they are against basic human rights, remember, it will lead to discontentment and torture. We don't want such things to happen. Now, when I speak of this, you might be knowing India became independent, and after becoming independent, we had ratified several international conventions on this. When I speak of this, we became a party to the Charter of United Nations. Now, under Article 1, Paragraph 3 of the Charter of United Nations, distinction based on race, sex, religion, and sectoral group is absolutely prohibited. No person is allowed to show any kind of discrimination between male and female and race. Apartheid cannot be practiced. That is how, remember, the independence movement of almost 60 countries have taken place. Now, non-discrimination, self-determination, all of them became part of the law of United Nations. A great writer who is the head of the Princeton Law School, Richard Fack, he was saying, in support of this human rights, there are certain resolutions which are binding. It gets the characteristics of customary rule of international law. They get the characteristics of customary rule of international law for the simple reason. Before the resolution is moved, the permission how the House is taken. When the permission of the House is taken and after its permission, if the resolution is passed unanimously without dissent, it is an instant customary international law. Now take the instance of self-determination. And self-determination is each country is sovereign to have a government of its choice. And colonialism had to come to an end. Then thereafter you have resolutions on what we call as sovereignty over natural resources. Each country is competent to determine and explore and exploit the resources by itself. Now there are many others because this is not the forum to speak on that. Now, when it is accepted and practiced unanimously with vote, it becomes instant rules of customary international law. This is what this person has said. And there was another Harvard scholar who equally supported him. Now, point is, the Charter in 1 paragraph 3 just indicated discrimination based on race, sex, religion, and place of birth is absolutely prohibited. Thereafter, we have Article 55 of the Charter of United Nations. And it speaks exclusively about human rights and its protection throughout the world. And then Article 56, I just tell you the relevant portion, states are supposed to take joint and separate action for the enforcement of these rights which are mentioned in Article 55. So what do you mean by joint and separate action? You have ratified the treaty. United Nations has come into force in your country. And as per the law of the United Nations, you have accepted to accept it in the territory. But whether it is in conformity with the Charter of United Nations, this is one question. Now the second thing is, the other developments that has led is, after 1945, the Universal Declaration came into force. When the Universal Declaration came into force in 1948 on December 10th, remember, again with the voice vote it was adopted. There were 30 articles, 21 of which speak about civil and political rights. And the remaining 7 articles speak about economic, social and cultural rights. Now at that time, Lord Denning once gave a judgment in a court of law in England, how it impacted for the adoption of international covenant on civil and political rights. Lord Denning, in one of the judgments in England, he just pointed out, the Universal Declaration has no binding force. In the Universal Declaration, there are no litigants. Under the Universal Declaration, you cannot book a case. It is, to a certain extent, is a useless document. The United Nations realized the pulse of the problem and the gravity of the situation, and then immediately called the Human Rights Commission to have a convention on human rights. And immediately, remember, by 1950-51, the United Nations Convention on Civil and Political Rights came in. But then, there were differences of opinion. States were not prepared to ratify. See, from 1951 to 1967, they dragged, and in 1967, it was adopted. Both the economic, social, cultural rights and civil and political rights. And they came in 1976. When once it was adopted, minimum ratification, 35 members had to ratify this, otherwise it would not come into force. And it took another 10 years, 1976, and it came into force. And India is a party to it. All rights, basic rights, which are sacrosanct to women, are being enshrined in the civil and political rights, in the economic, social and cultural rights. How long we can bluff the people of the world without implementing it? These are a few of the things which I just wanted to bring in. Many things can be spoken, but I just want to read a statement which was stated by the Honorable Justice Gajendra Gadkar. Honorable Gajendra Gadkar, in one of the writings, which was published in Bhavan's Journal, it was in 1971, as early as 1971, he indicated the non-implementation of the provisions contained in Article 44 amounts to a grave failure of Indian democracy. Amounts to a grave failure of Indian democracy. He said whether or not polygamy should be allowed, what should be the line of succession, what should be the share of different heirs, what should be allowed, what should be the law of divorce are matters which should be determined not by scriptural injunctions, it is by rational considerations. This is what he has said. So first is rationality should prevail, rational consideration should be there, and principle of tolerance, which even Will Durant in his book, the last 11th volume, Lessons of History, points out. It is because of the tolerant civilizations have survived. If intolerance continue and continues to flourish, all of us will perish. Once again, thank you with best wishes.